Round the courtroom. This is case IT 0891T, the prosecutor versus Mićo Stanišić and Stojan Župljanin.
Thank you, Madam Registrar. Good morning to everyone. May we have the appearances today, please?
Good morning, Your Honours. Starting, as I say, with the most important person, our case manager, Sebastian von Herdonk, Joanna Corner, and Matthew Olmsted for this session.
Good morning, Your Honors. Slobodan Zečević, Eugene O'Sullivan, Ms. Tatjana Savić, and Andrea Zečević appearing for Stanišić's defense this morning. Thank you.
Good morning, Your Honors. Radovan Karadžić, Aleksandar Aleksić, Michelle Butler, Leonard Poulsen, David Martini, and Miroslav Čuškić with Joyce Bukestein appearing for Župljanin defense today.
And Your Honours, I'm so sorry, I forgot to mention that our intern, Lucy Eastwood, who's gripped by these proceedings, is back today.
Thank you. I believe that when we took the adjournment yesterday, Mr. Kurgovich was about to hand over to Mr. Aleksić. Yes.
Good morning, thank you, Your Honours. In the first part of my presentation, I'm going to deal with the credibility of some of the prosecution witnesses, and since a majority of them provided their testimonies in closed sessions or private sessions, or they had protection measures granted to them, I would kindly ask the trial chamber to move into private session for a moment so that I can proceed talking about those witnesses.
I would like to say something about the testimony of witness Ljubicinac, briefly.
Witness
Ljubicinac was, as he himself put it, born in 1949. He graduated from textile industry high school and then military high school, and he graduated from the Faculty of Law in 1986, which means when he was 37 years old. Prior to 1992, he did not discharge any duties within the ambit of the military judiciary, i.e. military courts or military prosecutors' offices. In other words, he had no previous experience whatsoever. As for his testimony, the witness denied ever having seen document P1284.10, namely guidelines for the work of military prosecutors' offices issued by the prosecutor's office attached to the main staff of the Army of Republika Srpska. These guidelines, at pages 15 of the Serbian version and 9 of the English, read, and this is the chapter dealing with crimes against humanity and international law, and it reads, in order for the command of the main staff to have full insight into the type and number of these crimes, all unit commands shall be duty-bound to work toward uncovering all cases of war crimes against humanity and international law in the areas of their responsibility. Furthermore, on 2 occasions, the witness asked from the investigating judge to secure the release of suspects who were suspect perpetrators of some of the most serious war crimes. One of them is P1284.38. This is the case of the killings in Velagići. So this witness agreed that they be released from mandatory detention. And the crime in Velagići is something that Mr. Župljanin is charged with. And finally, let me speak about the testimony of Mr. or Comrade Radičević, as he wanted to be addressed during his testimony.
Thank you for this, Mr. Alexis. Before we proceed to the next witness, I'm not sure I fully understood the impact of your presentation regarding this witness. You said that he had never seen the guidelines for the work of military prosecutor's office, and that he had then asked the investigating judge to secure the release of 2 suspects. What is the implication of that? Can you just clarify briefly?
Your Honours, he performed the duty of the military prosecutor at the time. And in the context of him never having seen such a document, was he able to perform the duty of a military prosecutor? This being one of the basic documents governing their work under those circumstances. That was the meaning of my submission. And as for...
So your point is that this gentleman was incompetent as a military prosecutor. Is that it?
Yes, yes. Correct. Thank you. As for this other case, he broke the law on criminal procedure. He even asked that the criminal proceedings against these individuals be stayed or suspended. There was a term that in the BCS does not even exist in the legislation. And this is quite apart from the fact that he asked that these individuals be released. May I proceed?
Well.
Thank you. As for witness Radulović, he testified extensively. I would ask their honours to carefully examine his testimonies, both his answers given on direct examination and cross-examination. In great many of these answers, he changed his position. I would also suggest that their honours analyze in parallel the testimony of witness Šajnović and witness Radulović. Witness Šajnović on the issue of some of the very important issues, such as the establishment and the method of work of the Milish working group, who the sources of information were, and when and how they forwarded information to Mr. Župljanin. The answers differ from the answers provided by witness Radulović. I would now like to address the portion of the prosecution final trial brief where it is stated that Mr. Župljanin had effective control. Our learned friend, Ms. Butler, said something about it. Our position is quite the opposite. For a number of reasons, Mr. Župljanin did not have effective control. In paragraph 843 of the final trial brief of the prosecution, it is stated that one of the ways in which Mr. Župljanin exercised his control was by asking to be regularly informed by his subordinates, and reference is made to document P374. In our view, the document lends support to our case. The reason why the document was sent was due to the fact that there was no thorough or regular reporting. And that is why at one point Mr. Župljanin said daily reporting by the SJB to the operations duty officers of the CSBBL on important events is riddled with shortcomings and faults, and they consist of the following, and there follows a list of these. In his testimony, witness SZ003 stated that standard practice and procedures governing reporting were not always adhered to in terms of the accuracy of information or timeliness. Some of the dispatches were incomplete. Some of the incidents were not reported on at all, or were not reported on in time. And some people were not diligent enough in compiling these reports. And this can be found at transcript page 24399 to 24400. At paragraph 844, the prosecution say that in addition to the written correspondence, Mr. Župljanin attended meetings, and the mention is made of the 11th of July meeting. And his words about the rounding up of the Muslims and their detention in camps. Let's
The witness just mentioned was protected.
I just said strike it.
You did?
Yes. And I said, okay.
Strike it where it do, we'll have to have the redacted.
Izvinjam se.
I apologize.
Što se tiče te depeše od dokumenta 535,
As for the dispatch in document P535, which Župljanin forwarded to the chiefs of the SJB, in which it is noted that all the employees have to sign the solemn oath, it should be noted that it was forwarded on the basis of a dispatch written by Mr. Mandić, which is P535, which was not intended as means of discrimination against non-Serbian population, but rather the means of implementing the law of the new state, as the constitution had been declared and the law on internal affairs had come into force at the time. The prosecution witness Tutush confirmed this argument, saying that the new solemn oath was no different from the previous one, which was in force during the SFRY and which all the police employees were also obliged to sign. What is important is that Mr. Župljanin advocated multi-ethnicity, which can be found in P353 under item 2, which says it is in our interest to preserve the ethnic composition of employees in the SJB in accordance with the ethnic composition of the population in the municipality. Further, it is not correct that Mr. Župljanin was aware of what was going on in Sanski Most, as expressed in this paragraph. The defense claims that it was only on the 9th of September 1992 that in the dispatch which ST-161 sent, Župljanin learned from this dispatch that the policemen from that SJB were resubordinated to the army in Manjača. We will discuss this document later on in further detail. There is no evidence that the chief of the SJB from Kotor Varoš, Savo Tepić,
dokaza ikada lično, samostalno posjetio gospodina Župljana.
Ever personally visited Mr. Župljanin. ST-167, on the contrary, testified that for Tepić this was just an excuse to leave Kotor Varoš for private reasons. That is T-12417. In paragraph 848, it is claimed that Drljača was a close associate of Mr. Župljanin, who carried out his orders and reported to Mr. Župljanin. As for the situation in Prijedor and the role of the crisis staff and the local commanders of the VRS and their influence on the operation of the SJB Prijedor, we will discuss that in more detail later on, but I may say that because of all this, the Prijedor SJB was completely independent and was acting without any influence from the Banja Luka CSB. The prosecution witness Gajić confirmed that during the indictment period, the SJB chiefs often acted beyond the framework of their duties, that they refused to obey Župljanin's orders and instead acted in accordance with the orders of the local crisis staffs, or rather the army, which can be found on page 12910. He especially emphasized that the SJB Prijedor disobeyed. It was evident that Simo Drljača was not implementing the decisions of the Banja Luka CSB, which is page 12910 and 14. Witness Mačar, who was a high-ranking employee of the Republican Ministry of the Interior at the time, also testified that on the occasion of his visit to Prijedor, Drljača told him that neither the Banja Luka CSB nor the Ministry of the Interior was superior to him, i.e. to Drljača, and that his real superiors were the municipal crisis staff and the municipal authorities, which can be found on pages 22972 through to 79 of the transcript.
O Župljaninom nedostatku autoriteta da smeni Drljaču govori činjenica da...
The fact that testifies to Župljanin's lack of authority for relieving Drljača of his post is that the local municipal assembly from Prijedor relieved Drljača of his duty in 1993 only after Mr. Krajišnik, who was the parliament speaker at the time, had visited Prijedor. And even though our colleague said yesterday that there's no evidence of that in the case file, I would like to point out to the trial chamber that prosecutor witness Mišković talked about that at the transcript page 15273. As for the problems relating to the conduct of Mr. Drljača, Mr. Župljanin discussed that with prosecution witness Radulović. He informed him that it was impossible to remove Drljača, that there had been various attempts to do so, even by some armed groups, but that they had all been unsuccessful because Drljača was simply too powerful because of his close relations with the local crisis staff and the local commanders of the VRS. Radulović further testified that the removal of Drljača from his power base in Prijedor would have a very uncertain outcome and could cause even more problems, which can be found on transcript page 11088. As for the situation in Prijedor, we should take into account that 612 policemen from the SJB Prijedor were resubordinated to the army, the local brigades in combat operations, without any approval of the Banja Luka CSB. P689 is the reference. In paragraphs 856, 857, and 862 of its final brief, the prosecution claims that Župljanin did not take any measures to take disciplinary proceedings against policemen, nor did he file criminal reports against them. The defense refers to a section of its final brief where we deal with count 12G of the indictment, and where we clearly show that what the attitude of Mr. Župljanin was. Further, the prosecution claims that can be found in paragraphs 864 through to 867, 869 and 870. They claim that crisis staff did not influence Mr. Župljanin's effective control or reduce it. We invite the trial chamber to review section 12B of our final brief, where we deal with this topic. Many prosecution witnesses testified that the municipal crisis staffs, frequently together with the army, usurped Mr. Župljanin's ability to issue orders that would be complied with. It is mentioned there that Mr. Župljanin forwarded some decisions of the crisis staffs, but we claim that in his dispatches, Mr. Župljanin forwarded the decisions of government organs which were in accordance with the law, as, for example, P594 and P1883 show. In Exhibit P594, this is a decision that no one is allowed to leave the territory of Krajina carrying an amount more than 300 Deutschmarks without a certificate from a bank that the money was taken from the bank. We claim that such a law had already existed in the former Yugoslavia and that the objective was to prevent money being taken out from the country. Similarly, P1883 was an enactment whose purpose was that able-bodied men, regardless of their ethnicity, should not avoid their legal duty and that they should respond to mobilization call-ups. Paragraph 871 to 881 of the prosecution trial brief once again contains the claim that the VRS did not reduce Mr. Župljanin's effective control. We discussed that in detail in our final brief. And as for resubordination, the position of the defense is completely clear. During the trial, the evidence showed without any doubt that resubordination was the factual situation which was caused by the principle of the singleness of command. We will discuss this further a bit later on. Let me just point out that expert Kovacevic discussed that. So did the trial chamber witness Lisica. And we should note that these positions of the defense were confirmed by many prosecution witnesses. We discussed that in detail in paragraphs 222 through to 228 of our final brief. Further on, in paragraph 875 of its final brief, the prosecution claims that Mr. Župljanin distinguished between policemen who were resubordinated to the army and were involved in combat activities and those who were not resubordinated. They give reference to Exhibit P624. Reading this document in detail and analyzing it shows clearly that Mr. Župljanin had in mind, on one hand, the policemen who had been resubordinated to the army in combat operations, and on the other hand, members of the police who had been permanently assigned to the army. That is to say, they were not members of the police anymore, but they had rather become members of the army and had different tasks. As for resubordination, my learned friends from the prosecution changed their position over the last few days and said that even if this did happen, that is to say, even if police members had been resubordinated to the army, the resubordination only had to do with combat operations on the front line. Prosecution witness Krajić talked about this, and he was the SJB chief in Skender Vakuf. On pages T14042 and 043, he said that at the time, in August 1992, one of his units was resubordinated to the local VRS brigade, and that the only task of this unit was to secure a certain road. As for the tasks which the resubordinated policemen had to carry out, we should pay attention to Exhibit P5613, dated the 18th of September 1992, in which Mr. Župljanin, I apologize. We're talking about the 18th of September 1992. And it is a document in which Mr. Župljanin says that there are problems and that outside the knowledge of the chief of the SJB and CSB, policemen are engaged in combat operations. In accordance with the agreement with the highest-ranking representatives of the army, it was necessary, as he says, and the situation is repeated even in September 1992. As for the communications system and how it operated, this is discussed in paragraphs 881 through to 886 of the prosecution final brief. My learned friends touched upon that yesterday. Witness ST167, who is an expert in this field, when presented with Exhibit P1468, which is one of the reports for the year 1992, the witness testified that the statistics show that there was a sharp drop in the number of sent and received dispatches in the period between the 11th of June and the end of 1992, and that also refers to the exchange of dispatches between the Banja Luka CSB and the Kotor Varoš SJB. Prosecution witness Kezunović confirmed that in exhibits P595 and P621 contain precise statistics about the number of dispatches sent during the first 6 months of 1992, and also the period between the 1st of July and the 30th of September 1992. My learned friend, Mr. Krgović, talked about that yesterday, so let me not repeat that. But I will say that the significance of these numbers is emphasized in the report on the number of dispatches sent in the first 9 months of 1991. That report contains the total number of more than 200,000 dispatches sent and received. Even though the prosecution claims that there is no evidence for this position, except from the testimony of witness Kezunović, we point to Exhibit 2D52, which is a report on the work of the Banja Luka CSB for the first 9 months of 1991, in which, on page 12, in English version it's page 11, it says that the total number of the received dispatches is 188,168, and those that were sent were 39,858. It should be noted that this information covers 15 SJBs which belonged to the CSB at the time, as opposed to the 26 SJBs which were part of the CSB in 1992. This was also discussed by the prosecution witness Araković, who explained the problems which existed in Banja Luka and the entire Krajina area. There were periods when the electricity was down for 2 months in Banja Luka and no fuel was available.
I'm sorry to interrupt you. Our legal officer just drew the Chamber's attention to something that you said in relation to an exhibit. It's page 20, line 8. And the transcript records that you referred to an exhibit P5613. I don't think we got that far. We got far enough for sure, but we didn't raise it until to the 5,000s.
Yes, of course, Your Honors, it was a mistake. It is exhibit P613.
Please forgive me for interrupting you.
Due to the shortage of time, I cannot go into great detail on the issue of communications, but I would like to say that Mr. Župljanin, at the collegium meeting which was held on the 11th of July 1992 in Belgrade, said that the main communication system had been destroyed. Furthermore, when it comes to reporting, the prosecution says that Mr. Župljanin received reports drafted by the Miloš group, and this doesn't arise from either the testimony of Mr. Radulović or the testimony of the defense witness Šajnović, who said that the Miloš group reports were not sent to their superiors, but rather they were sent to the CSB in Belgrade. This is on page 25120. to corroborate this part of Shajnovic's testimony, I would like to draw the trial chamber's attention to P1328.13. This is an official note which was drafted in 1993 at the State Security CSB Banja Luka, and in which it says something about the establishment of the Miloš Group. And I quote, bearing in mind that over 2 years ago we were officially established as a group intended for cooperation with the MOP of Serbia, we had an occasion on several occasions to spend some time and get in touch with the colleagues in the MOP of Serbia. From the beginning, we agreed amongst ourselves that we will focus our interest on collecting intelligence about the enemy armed formations, the enemy intelligence services, associates, and other collaborators of the enemy, and so on and so forth. In paragraphs 891 to 909 of the prosecutor's final brief, there is a reference to the information that Mr. Župljanin had with regard to detention centers. In paragraph 891, there is a reference to a document which is P1560. We claim that the introduction into this document says, or it arises from that introduction, that that decision was in keeping with the decision of the municipal crisis staff in Prijedor, and that the purpose of that decision was to detain people who were captured in combat and who had to be interviewed. The defense repeats and reiterates its position that the tone, the language, and the official nature of this order points to the fact that this was a military facility. Moreover, it arises from the testimony of Mr. Radulović on page 11126 that Mr. Derlocha bypassed Mr. Župljanin and he deprived him of any information. Furthermore, in paragraph 891, the prosecution claims that in May, Radulović twice reported the problem of the mass arrests of the non-Serbian population and that the detainees were not provided with adequate food or accommodation. The prosecution refers to two reports sent by the Miloš Group, and I already said that there is no single piece of evidence to the effect that those reports were ever sent and that Mr. Župljanin received the Miloš Group reports. As for the crimes committed in certain detention centers, and Mr. Župljanin has knowledge about that, a lot was said about that in our final brief. I would like to add to what was already said that Župljanin did not know anything about those crimes. Our thesis was corroborated by the fact that the information that he received from Radulović and our learned colleagues said that that had happened several days before the collegium meeting on the 11th of July. And that he immediately reported that to the collegium and he demanded that measures should be taken. In August, he set up a commission whose task was to examine the conditions and the treatment of the detainees in those facilities. This you will find in P601. I will revisit the issue of that commission a bit later. Župljanin's lack of knowledge about the events in Prijedor was testified about by witness ST241. He was one of the employees of the National Security Service, and as such he was sent to Omarska. The witness testified that there were never any contacts between the operatives who participated in interviewing the suspects in Omarska and Mr. Župljanin. You will find this on page 16745. Župljanin's lack of knowledge about the conditions in Omarska is corroborated by document P1560. It is stated in this order, I strictly forbid conveying information of any sort with regard to the functioning of this collection center. All official documentation has to be kept at the center, and it cannot be taken out of the center or destroyed without the approval of the chief of the police station in Prijedor. The literature emphasized the weight of any breach of this order, and he added that he demands all the personnel and especially authorized officials to strictly adhere to the instructions provided herein. When it comes to the allegations in paragraph 9002, according to which Mr. Župljanin visited Omarska twice, save for the testimony of witness ST23, there is no other evidence. I've already addressed the credibility of this witness, so I wouldn't want to waste any more time on that. Witness Jankovic testified that before the arrival of the delegation at Omarska on the 14th of July, the literature had rearranged conditions in the prison because of that delegation. Mišković admitted that the detainees had looked unkempt and that they had not been clean-shaven, and Župljanin drew everybody's attention to everybody at the meeting on the 11th of July. In any case, he did not mention any signs of physical maltreatment. Serdić, the president of the Red Cross in Prijedor, confirmed that the Red Cross had opportunities to visit the prisoners and bring them food and medicines. When it comes to paragraph 904, it is stated in that paragraph that General Talić stated that no single soldier was involved in the massacre at Karaterm on the 25th of July. The position of the defense is that we do not challenge the fact that there was indeed a crime committed against the prisoners in Karaterm, including also the murder in room 3. Prosecutor witness ST151, who was at Karaterm at the time, stated that people who stormed into the room 3 were not guards but soldiers who had arrived from outside, and that those who controlled Karaterm and Ternopol wore olive drab and camouflage uniforms. This was subsequently confirmed by prosecutor witness ST183. He stated that Colonel Arsic had taken over command in Prijedor and subordinated local police forces. When it comes to paragraph 913, the interpreter's correction, paragraph 919, we contest the allegations in this paragraph where it is stated that at the end of July or beginning of August, Radulović informed Župljanin about the meeting in Teslić. Amongst others, General Mladić and Lisica were also there. And the leadership of the army ordered the local police to expel the non-Serbian population from the territory. This is not true, and this was confirmed by the prosecution witness SD191, who attended the meeting himself. He testified that the only time when Mladic was in Teslić, that was in late September or early October. And that was the only time that Mladic visited Teslić, that there were about 30 to 35 people attending that meeting. I would like to mention that at that time Mr. Radulović had already left Teslić. When witness 191 was faced with this document, the witness said that nothing had been said at the meeting about ethnic cleansing, and that the report is completely fabricated and that its contents completely false. The witness said nothing that is mentioned here did not happen at the meeting. That is on transcript page 18548. Listica was also asked about the document and about that meeting, at transcript page 26902. He was also asked about Mladic's diary. According to Mladic's diary, that meeting happened on the 5th of December. In paragraphs 9 to 2, the prosecution says that ST-174 constantly complained to Župljanin about the Serbian police that committed crimes against the non-Serbian population. I already discussed the credibility of this witness at the very outset of my presentation, so I don't want to repeat myself. We're claiming that Mr. Župljanin undertook a number of measures against such unlawful actions. The prosecution witness ST-225 confirmed that he was witnessing the police investigation into the explosions and planting explosive devices on the houses of non-Serbs. He also supported the position of the defense that it was the army that should have investigated the aforementioned incidents. He also confirmed that soldiers, when they were coming back from the front line, usually shot in the air and caused trouble. On one occasion, they even set fire near Podpečina Mosque. When it comes to paragraph 9 to 3, and the red van which is mentioned in there, the defense would like to recall the testimony of witness ST-223, who stated in his testimony that in any case the police did whatever they could, and he admitted that he was not absolutely sure whether anything was done against those persons, whether they were indeed members of the army or perhaps the police. When he was faced with the evidence, according to which Župljanin had ordered the arrest of Goran Gatarić or Gavrin, for whom ST-223 believed that he was one of those who rode in the red van. Later on, it was established that Gavrin was a soldier, and a report by the military police confirmed that he was arrested in 1993 on account of the crimes that he had committed in 1992. In paragraph 799, it is stated that Župljanin, when he wanted to do so, could undertake certain measures, and the example of Teslić is mentioned, and the arrest of the Mićo group. I would kindly ask the trial chamber to pay attention to the part of the testimony of witness Radulović on transcript pages 11087 and 11088, where he explained the difference, and where he said why it was possible in Teslić and not in Prijedor, primarily in Prijedor and in other regions as well. In paragraph 803, there is a reference to the fact that Župljan had given authority to SJBs to investigate grave crimes. It was not Župljanin's decision. It was the government of the Republika Srpska that made the decision. L55 says that basic courts became responsible for all crimes, and in line with that, basic courts became competent for investigation of all the crimes. So the SJBs were supposed to investigate all crimes, including the gravest of crimes. As for the operative plan, or paragraph 804, it is stated in here that Mr. Župljanin, although he already had information from two previous reports about the number of crimes committed in the course of April, he did not approve the plan before the 25th of May. I invite the trial chamber to carefully inspect the document. I believe that it is very important. It is stated in that document that this was the plan to elucidate robberies, terrorism, extortions, and other such crimes, and that those crimes escalated in number in Banja Luka from the beginning of April of that year. In that paragraph, the prosecution criticizes Mr. Župljanin for having done very little, and that what he did was negligible. In that document, there is a detailed list of measures that were supposed to be taken. It is stated that over 40 people had to be arrested. It is stated how many crimes were committed. It is stated that 76 explosive devices were planted. Some very specific measures are listed as how things had to be done. And at the end of the document, Mr. Župljanin says that since the aforementioned persons organized themselves as members of the SOS, that they were well armed, and some of them had even been mobilized into JNA units. Their arrests had to be carried out by the units of the military police in order to implement the plan efficiently. Things had to be coordinated with regular military courts, and at the end it is stated, until the moment the military prosecutor's office and the military courts are established, there are no conditions in place for the full implementation of the plan, because these people are mostly military conscripts, former TR members, which is why civilian courts and prosecutor's office cannot be involved in the conduct of proceedings against them. Your Honours, I am going to say just a few words before the break.
First, at page 13, line 18 of today's transcript, there's an imprecision. As it came in, it turns out as if Mr. Alexić disagreed with what Ms. Butler said, and that was, of course, not the case. He agreed with what Ms. Butler said and disagreed with what the prosecution had to say. Let me, Your Honours, turn to several matters arising from the 30 May closing arguments of the prosecution, specifically page 27440, where the prosecution say that in the case where a reserve policeman is taken off the lists of the police and transferred to the army, that it may so happen that the member of the police who committed a disciplinary or criminal offense, upon his transfer to the army, may commit a similar crime, and since since the VRS was not privy to what sort of conduct he had engaged in before joining the army. Now, this statement is completely untrue. The evidence, documentary, and the testimonies confirm that whenever an individual was taken off the reserve police force and transferred to the army, this would be reflected in the personnel file, which would also be sent to the army through the Ministry of Defense. Now, in view of the fact that the personnel file of every individual had to contain details about the individual's discipline and possible disciplinary procedures against him, this position expressed by the prosecution does not reflect the actual state of affairs. Furthermore, at paragraph 738 of their final brief, the prosecution cited Defense Exhibit 2D63. They discussed the fact where it was that the members of the special police unit ended up after the unit's disbandment. I established that in the English translation in e-court, the first page of this document is missing. Can we call up to D63 now? Page 1.
I pogledajte ovaj deo gde se kaže...
Mr. Krgović, speak into the microphone, please.
Gde se kaže da su...
Look at the first part where it says that most of the members of the former special detachment were within the wartime assignments of the VRS.
A ne u jedini...
And not on the lists of the police force or any sort of special police that was allegedly set up by Župljanin. And there is no evidence to prove that Župljanin set up any special police units in the course of 1992, as of autumn 1992 on to 1993.
Časni sude.
Your Honours, I would like to say a few words about Mr. Stojan Župljanin's personality and character, and I will be sharing this topic with my learned friend, Ms. Butler. Perhaps we can take the break now, so that we can look into the part that we will share and see if we can reduce it somewhat and bring our closing arguments to an end.
Yes, so we will return in 20 minutes.